A very good evening and a warm welcome to our next episode on Law and Order. And today we are going to speak about something novel to Sri Lanka, which was introduced within the past few years, and also something which is fastly being popular among the general public. So we are here to talk about the right to information. The right to information was introduced by the recent 19th Amendment, and now how does the public feel about the 19th Amendment? That is going to be our discussion today. And we are more than happy to welcome to our studio at Sri Lanka Rupavahini Corporation, Chamindri Saparamadu, attorney at law. She has been working on issues of governance, accountability, and right to information for many years, and it's a great pleasure to have you here.
Thank you very much, Shihara. Thank you for inviting me to this discussion.
And also, my question to begin today's discussion, just to put it out very openly, what is right to information, and what benefit does it serve to the general public?
Right to information is a right that is given to every citizen of Sri Lanka to access information that is in the possession or custody of any public authority. Now, information, what constitutes information and what is a public authority is defined in the Act. I will come to that later. It was first introduced in Sri Lanka as a fundamental, through the 19th Amendment, as a fundamental right and incorporated into the Fundamental Rights chapter. Then thereafter in August 2016, the Parliament enacted the Right to Information Act, which provides a mechanism by which the citizens can access information. The principle underlying the right to information is that the sovereignty lies in the people, and it includes power of government as well. So, people exercise this power through their elected representatives and their government, and they also pay taxes, which gives them then a right to know as to how the elected representatives function, how their government functions, and how decisions are made, how their tax monies are spent. So, that is the principle underlying this right. If you look at this right, there are two elements. First of all, it gives the citizen, every citizen, a right to obtain information by submitting an information request. And also it compares, then the second element is that it also compels every public authority to disclose information voluntarily. So, there are two aspects in this right, and that is exactly the RTI legal regime. And if you if I talk about benefits, I could see several benefits, but I would focus on the most important ones. It is RTI is actually a tool to realize fundamental rights, because if you look at accessing a citizen's entitlements and rights, they first need to have information on to know what their rights and entitlements are. Then if a fundamental right is violated, citizens need to have information first to know, to be able to seek redress for those violations. Then secondly, right to information strengthens democratic governance, because if you look at the main elements of democratic governance, those are transparency, accountability, responsiveness. And you need information to hold your governments accountable. You need information to make them respond to your needs and demands. Then also, so therefore, there is a direct link between right to information and those elements of democratic governance. And then democratic governance also entails participatory and inclusive decision making, rule of law, productivity, equitable access, and so on. And right to information is critical to be to realize those elements of democratic governance. It also actually brings the state and the citizens closer to each other by enhancing the trust and confidence that each other between each other, and also the mutual cooperation. So, the right strengthens the social contract between the citizens and the state.
So also now when the Right to Information Act was brought into Sri Lanka, there was so much of media hype circulating around it, and there were certain claims that this was one of the most progressive legislation Sri Lanka has ever seen, and this is one of the most it's one of the strongest right to information acts in the world, so on and so forth. So if you compare the right to information in Sri Lanka with maybe South Asia or even the rest of the world, where do we stand?
Our legal framework is ranked very high globally. There is an organization, a Canadian organization that works on democracy and media freedom of expression called the Center for Law and Democracy, and they do a global ranking of right to information laws across the world. Our law is ranked at 4th place out of about 120 odd countries. The ranking is done based on a numerical score that is given to the legal framework, and they arrive at this score based on various looking at various aspects of the law and how effectively the legal framework give effect to the right of access to information. So they look at various aspects of the law. For example, so a score is given to the type of information that people can access, the exceptions, the right to information requesting process, what kind of protections are there for public officers under this legal framework, and so on. So I'm very happy to say we are at the top of this ranking, Sri Lanka, but this is only on the legal framework, but the ranking is not based on enforcement. So that I have to highlight here.
Okay, so we discussed about what is RTI and what is the historical development which led to right to information in Sri Lanka. Now let's move on to the crux of the act. How do you see the Right to Information Act, and what is the process of obtaining information? I mean, very blatantly we could say that you know, people have the right to get government information, but how does it work?
First of all, if I may speak on what constitutes information. Information is defined very broadly in the Act as to constitute information that is in the possession and custody of any public authority. So regardless of the physical form in which information is preserved and maintained in public authority, citizens get access to obtain information, whether they are recorded in the form of documents, reports, emails, memorandums, correspondence, contracts, or even information stored in electronic format, and the citizens get access to even inspect documents, obtain copies, and also get whatever the information that is preserved in electronic format, get copies of that either onto diskettes or pen drives or whatever form. And also this right is people can access information in any public authority. Now, public authorities are also defined very broadly to include every category of state institutions, whether the institutions are at the central government level, provincial or local authority level, the elected bodies, government, that means ministries, departments, statutory bodies, and also private entities incorporated under the Companies Act, as long as the state or the public corporations hold 25% or more shares and or the controlling interest. Then public authority, even non-governmental organizations that receive substantial funding from the state or perform a public function is covered by this act. In addition, even private entities that enters into an agreement with the state to perform a public function. So, for example, a private entity that signs an agreement with the government to collect garbage, for example. So long as they perform that public function, the citizens get a right to access whatever the relevant information they require. The requesting process is rather easy, it is not a complicated process. Any citizen can submit a right to information request in writing to public authority and specifying what kind of information they need. But in case if a citizen is unable to submit a request in writing, they can submit an oral request, and the information officers appointed in all public authorities have a duty to record that information request. And also the citizens are not required to state the reasons as to why they want this information. In our public authorities, now in the state sector there are about 1,800 public authorities. Every authority has to appoint an information officer and a designated officer in terms of the law. So the citizen has to submit this information request to the information officer, and then within 14 working days the public authority, the information officer, has to respond to this information request. Either if the information officer decides to process the request, then he has to say this is the fees that has to be paid and then provide the information, or deny the supply of information under the exceptions that are there in section 5 of the Act. So it is actually not a, I mean it is in a sense a qualified right, because although the citizens can access this information, this process is also subject to certain exceptions which are specified in section 5 of the RTI Act. So if the, for example, the information undermines the national defense, security, territorial integrity of the country, or if it somehow it's unwarranted invasion of somebody's privacy, you know, unless that person consents, or there's a decision that the public interest overrides and that, you know, that information is needed in the public interest, or it actually even undermines or cause some kind of prejudice to Sri Lanka's relations with another country, or even cause some kind of prejudice or causes harm to economic interests, because for example premature disclosure of this information might you know, have an adverse effect on, for example, the taxation, you know, policies or foreign exchange control policies and so on. Or if it's actually the disclosure might even undermine the integrity of an examination conducted by the Department of Examinations, or even ongoing criminal investigation, or, you know, a court case, you know, if it amounts to contempt of court. So there are series of exceptions that are specified in section 5. But however, what is interesting in this act is that what runs through this act is that giving information is the norm and denial of information is the exception, because even in section 5, which specifies the exception, there is a public interest override, which says that if, for example, the disclosure of information serves the public interest and it outweighs the damage that can be you know, that can happen by disclosing, then the public interest take precedence. So supply of information is the norm that runs through the RTI legal regime.
And also during the process of obtaining information, you mentioned that there would be a fee involved.
Yes.
Would that fee be discouraging people from obtaining information?
No, actually, the fees are there in the regulations, but the fees are not very high. These are fees, amounts have been prescribed in the RTI regulations, but it depends on the number of copies, for example. Now, if it is a say a report of a commission of inquiry that runs into say 1,000 of pages, and then if you want like 10 copies of this report, then of course the fees could be a bit high, but it is not something that cannot be afforded by citizens as far as I can say. And so that is not something that could discourage citizens from obtaining information. If at all it's the lack of knowledge or an awareness about this right that might not, I mean, we can go to that I think question later. I also like to say here that now after having submitted the information request, if the information request is denied or not processed for some reason, the citizens also get a right of appeal, and within 14 days they can appeal to the designated officer in the same organization. So, as I said before, every public authority has to necessarily appoint an information officer and a designated officer who is an appellant officer. And so, the citizen gets a right to appeal against the order of the information officer, firstly to the designated officer. And thereafter, the designated officer is expected to, I think, give the decision on appeal within 21 days. And then if the citizen is once again not happy with this, satisfied with the order of the designated officer, he or she can appeal to the RTI Commission within I think 2 months, and the RTI Commission is supposed to give its decision on the appeal within 1 month. So, I have not mentioned specifically, but in terms of the RTI Act, there was a RTI Commission that was set up, constituted. It comprises of 5 members who have been appointed on recommendations of the Constitutional Council, and the Commission's mandate is to hear appeals, monitor RTI implementation, and also ensure compliance by all public authorities. Then also in addition provide the necessary guidance and also conduct educational and training programs.
And also now you mentioned the process dealing with RTI in Sri Lanka. Has the government taken steps to make this process popular among the general public?
The government has certainly taken steps, but I think that there could be more focus in that area, because I would like to speak of that as a challenge in RTI implementation. Because if you look at the RTI movement in Sri Lanka, it is in a way a bit of a top-down process, because we've had RTI advocacy for over 10 years in Sri Lanka, but the initiative has always come from either the political parties or civil society. This is very different to the RTI movement in India, because in India the movement originated in a small village in the state of Rajasthan, when people actually demanded certain information relating to their workers, entitlements and remuneration and so on. So, in Sri Lanka we've had RTI advocacy for about 10 years. Starting from 1994, it was started with the cabinet paper that was submitted by the then Minister of Mass Media, Honorable Dharmasiri Senanayake, when he recommended to the cabinet that the importance of introducing RTI legislation. During that decade, there was this interest around the world for RTI legislation, but somehow when it came to actually passing legislation, in South Asia, it started only in the year 2000 and so. So, but right through advocacy has been at the level of political parties or civil society. So, there is this great need to now educate the public of this important fundamental right, and I think the government has done quite a lot, but I think there still needs to be more focus. And it is not just the government, it requires the collaboration of all stakeholders, the media, the civil society very specifically, to go out now, reach out to the people in the remotest areas of Sri Lanka and tell them that there is this very important right. which is actually empowering, citizen empowering tool, and that people can access the information in the state. It gives them the right to demand their governments as to why certain, for example, services are not provided for them. I mean, they can access whatever the information they require. Awareness programs have happened in the last 3 years. There have been many civil society organizations, community-based organizations that have done various types of awareness, raising, from mobile clinics to street dramas and so on. And the government also has used the mainstream media to tell the people about this important right.
And also, my final question to you is, why do you think like you gave me an example of India, where RTI actually rose from the grassroots and it was a requirement of the general public. Why is it that in Sri Lanka, the general public or the grassroots level community have not fully recognized RTI or its users in comparison to other countries?
I don't think it's a question of the public not recognizing. It's just so happened that the movement originated differently. And I'm sure now when you see how the public is using this, important right, that there is a lot of interest among public, because the number of RTI requests that are being received by public authorities has been increasing since 2000. I mean, the law became fully operational in February 2017. So we are into, I think, now the 2.5 years of implementation. The number of RTI requests have increased across all public authorities, and the number of appeals that the RTI Commission also is receiving, now the numbers are going up. So it's not a question of the public not seeing the value of it. It's just that since this was a movement that originated differently, there is a need to reach out and educate the people. Also, I think in Sri Lanka, and if you compare Sri Lanka and India, our public interest activism has not been as great as in India. We have seen that in other areas as well, where public interest litigation and so on has been very effective in India. So that it so happens, our society happens to be like that, where a lot of the policy reforms and all that seem to start from the top and seem to be actually conversations that happen among certain elite groups, the educated middle classes and so on, and then their views seem to permeate to the grassroots level. So it's a fact about our society. So we, it's something that I think we have to confront with in terms of even our democratization efforts and so on. But as far as the law is concerned, RTI law in Sri Lanka, now the interest among the public is actually definitely increasing, which is why the people are using this now to access information. I have also come to hear of the legal professionals using this to obtain information that are relevant to their cases and so on. So definitely there's a great interest seem to be mounting among the public.
Certainly, RTI is something new to Sri Lanka, which was introduced with the 19th Amendment, and now we see a general progress where more and more people start to use their right to information in gaining information from the public sector. So with that, we conclude today's segment on law and order for today, and we are thankful on behalf of Sri Lanka Rupavahini Corporation to Ms. Chamindri Saparamadu, attorney at law. I would rather call you an activist in governance and accountability and also right to information. So it's a great pleasure to have you here. And with the aim of meeting you next week, we conclude today's program. Wish you a pleasant night.